Hello, and welcome to the Innovation Women Speak webinar series. I'm Bobby Carlton, the founder of Innovation Women. Innovation Women is a visibility bureau for entrepreneurial, technical, and professional women. Our mission is to eliminate the all-male, all-pale, and often all-stale panels you see so often at industry conferences and events. We connect women with speaking opportunities, and we connect event managers with awesome speakers who just happen to be women. Innovation Women is so much more than a traditional speakers bureau. Event managers can search the database for free, and our speakers pay just $100 a year to become a member. They get a profile on the platform and access to lists of speaking opportunities, as well as a number of other cool benefits. As a speaker on our site, you'll see how often your profile is visited. Speakers can also notify us to promote their speaking engagements, and event managers can easily create and store lists of speakers on the platform as they build out their events. If you'd like more information on Innovation Women, check out our website. For our webinar attendees, we have a special offer of 20% off your first year. It's like coffee money at that price. You probably spend more visiting Starbucks. So before we move on, just like to do a quick look at what's coming up on our webinar schedule. This year, our webinar series has a new theme every month. October's theme is cybersecurity. All of our webinar speakers are Innovation Women members. If you are interested in applying to be one of our webinar speakers, we post the call for speakers on our own platform. The deadline to apply for the next webinar is September 7th. If you're already a member, keep an eye out for these opportunities on the website and in your weekly newsletter. Before we get started with today's presentation, I want to encourage you all to sign up for our next webinar on September 16th. Tess Gadwa will be presenting actionable data. You'll learn to visualize, present dynamic data in the most effective and compelling way to facilitate interaction, to actualize, design data interactions for maximum impact and resonance, and synthesize, structure your data narrative so that visitors stay engaged. You can register for this webinar in the Attachments tab. And speaking of that Attachments tab, this is an annotated version of your screen. Below the video viewing window, there are tabs. The default tab is Ask a Question, and you can ask a question or make a comment at any time during the program. The Attachments or Links tab is where you see documents and links from today's speaker and the link to sign up for our next webinar. You can download the attachments at any time during this webinar and from the recording. The tab called Rate This helps us determine what you like. We read all the feedback. The Votes or Poll tab is where you see the poll from our speakers. She'll be asking you a question, and you can answer it right on the screen. You can enlarge your screen to view it in full screen mode, and if at any time you need audio help, feel free to click on the Help button at the bottom of the screen. If you can't hear the speaker or if things freeze, please try reloading the page. Today's webinar is being recorded, so if you'd like to view the webinar again, you'll be able to. We will send you the link after the webinar. So now, on to today's presentation. With us today is Hannah O. Hannah is an MIT-trained attorney who focuses on patent and trade secret litigation and licensing issues for innovative companies. And these include Samsung, Micron, Belkin, Alcon, and Novartis. As an engineer and as a large firm IP attorney, Hannah has frequently found herself as the only woman or one of the very few women in a room full of men. She is thus committed to mentoring younger women and helping them draw on their strengths to succeed in their fields. For those listening, please note you can ask a question at any time, and this webinar is being recorded for future playback at your convenience. We are so excited to have you join us here today, Hannah. I will turn things over to you.
Thank you very much, Bobby. Hi, everyone. I'm very excited to be here. As Bobby mentioned, my name is Hannah, and I am an intellectual property attorney. And I'm especially excited to be able to talk about two of my favorite topics today, one of which is intellectual property, and the other one is women in tech. And the fact that that's two of my all-time favorite things to talk about probably tells you what a big nerd I am. But I'm really convinced that those are very important topics. They're related, and they also sometimes don't get the attention that they deserve, especially as to at the intersection of the two of them. And I wanted to start out by first looking at where we're headed. So where do we want to end up at the end of our time together today? The first is I want to talk to you a bit about what intellectual property rights are and how you might go about determining what rights you have, and once you do, how you would be best situated to protect that property right. And I'm hoping to do that in the context of the larger developments in the industry and also in the legal context that this all takes place. And before we launch into it, I wanted to get a sense of where your familiarity and knowledge lies when it comes to intellectual property matters. So Bobby will help us launch a poll in a minute that you will see, and that will help me understand where your experience level lies and try to tailor my discussion today a bit in that direction. You know, whether you're already very familiar with it or not at all familiar with it, that might help me shape the discussion today a little bit. And while we're doing that, I also wanted to emphasize that this, of course, is a discussion that can't really be covered in the next, 30, 40 minutes, right? So what I'm hoping to do today is give you a overall primer on these issues, on IP and protection, and hopefully this will be a beginning of a longer conversation. I am happy to answer questions at the end of this session, but also feel free to reach out to me using the contact information that we'll share. And as I mentioned, these are my favorite topics, so I'm thrilled to talk to you about them, whether it's on the IP front or on the women in tech front. So when I initially started this was something that wasn't really familiar to me either, which is the role of women in IP. And I wanted to look at this chart, which shows you two things. So one, the top line shows you the percentage of patents where at least one of the inventors is a woman. And as you can see, that's about 20-something% currently. The second line that you see is if you look at all of the inventors, right, who are named on patents, what percentage of those inventors are women? And that is just a little bit above 10% currently. And this graph, I mean, at first blush, right, it might seem promising in that there's an upward trend. We're certainly doing better in this regard than before. And of course, the values were so low that they were barely 5%, into the 80s, which is surprising. But we certainly aren't anywhere near where we want to be, even in 2020. And if this current trend continues, we probably won't be for many decades to come. And I don't think that's acceptable. And I wanted to make sure that we're aware of that and that this formed the context of what we talk about when it comes to IP issues. Looking at this slightly differently. So as I mentioned, if you look at all of the patents, and by the way, this is in the United States only, about 22% of them have at least one woman inventor. Said differently, this means that 4 out of 5 patents in the US, right, have an all-male inventorship. And that's a little bit lower in the US compared to the 30%, which is for international patent applications. And another metric that's helpful here to consider is the woman inventor rate. And that in the US is what percentage of all patents name an inventor who is a woman. And that's about, as I mentioned, 13%. What's interesting is that if you just look at the new inventors, that percentage is actually a bit higher. 17% of them are women. So again, there's a general increasing trend, but that increase isn't really as large as we would like them to be. And we would want to see that trend continue, but just at a faster rate for sure, right? Another interesting metric is that if you look at repeat inventors, so those inventors who invented before and have been named in patents before, but are named in subsequent patents, that ratio is actually not that different for women and men. It's about 46% of women will invent again, 52% for men. So it suggests that once somebody does engage in inventing activity, they're likely to continue that, so the difficulty may lie in that initial step into being an inventor. And I've mentioned this in the patent context, but in the other IP rights, which include copyright, trademarks, and trade secrets, that is also similar. And they're not as well tracked as patents because things are just more quantitative in the patent world and there's a lot more data available. But in the copyright context, just as one example, what's been traditionally considered to be fine arts, right? So sculpture, literature, paintings, composition, those are all traditionally male dominated, right? But now that's been changed a little bit, but before mostly men were participating in these activities, and those are or have been traditionally considered to be within the realm of IP protection, in particular copyright. Whereas for domestic fiber, so art that has been considered in the past to be mostly in the realm of women, such as needlework, knitting, crochet, patching, quilting, that has for a long time been considered not to be within the realm of IP protection and copyright. So all of that to say, this is not limited to patents, but it is a pretty big problem sort of throughout IP rights. And I believe it's important for us to know. So why is it important? Why do we care? And why do I specifically care, right? So as I mentioned, or as Bobby also mentioned, I'm an engineer by training. I worked in biotech companies. I worked as a scientist in lab. And then afterwards, I branched out to law. I helped draft patents and write patent language as a patent agent. And currently I'm working in litigation, mostly in trade secrets and patents with tech companies, ranging from semiconductors, pharmaceuticals, biotech, and others. And in all of this, through the course of my career, I've just really been surprised and also, frankly, disheartened by how sometimes groups get marginalized, right, such as women, but others as well, like minorities, seem like sometimes they're not recognized for their contribution. And I think it's important for us, and especially those of us working in tech, or those of us working with others who work in tech or work with technology directly and use them in our day-to-day life, it's important to recognize and understand this disparity in terms of rights. So I'll start out by, looking at the different types of IP protection. And looking at the poll results, it looks like we have a pretty big variation. Some are experts, some are not at all familiar, but most of you have very little to at least some experience with it. So I'll keep that in mind and try to address that as I go through. But of the 4 IP types, I'll mainly concentrate my talk today on patents and trade secrets, both because of the limited time and also because that's where most of my experience and expertise is. And that's sort of more common among the tech fields. But I'm happy to talk about the other ones, afterwards in questions or some discussions later on after the webinar as well. And just to reiterate why this is also more and more difficult, the technology is evolving very quickly, and the backdrop of the legal landscape is also changing very quickly. And there's just more collaboration, cooperation, and more movement. So all of these, as I'll discuss in more detail later, lead to the fact that intellectual property is just incredibly important, but also incredibly more complex for us to understand. And for all the reasons I've mentioned before, I believe that it's really important for all of us to understand what they are and how we would need to go about protecting that information. I'll start out with patents, and they're sort of the more common type of intellectual property, especially in the tech field. And while people understand generally that it's needs to be something new, useful, and non-obvious, which are the general requirements for patentable technology. What's also sometimes get lost is that it is, if you look at the definition of it, it's new and useful improvement of existing technology. So while many people tend to think it has to be something entirely different from what's out there, right, or something that has never existed before, it's usually much more common for it to be directed at something that exists out there already, but it is a very helpful and useful improvement of it. So I would like to encourage you to expand your view of patentable invention. And that's also an important note because sometimes certain groups may be less likely to think that they own a certain right or certain information that may be eligible for this protection. And for a patent, the most important aspect of it is the claims. And claims and patents are what's listed usually at the end. They're this sort of numbered list that very carefully delineates what your invention actually is. And that will tell you what you're claiming as your invention. So that has to be drafted very carefully. And after you submit your application, after 18 months, it will then be published by the patent office. So the patent is really rooted on this concept of you're going to describe your invention to others so that it's available for other people to read and understand and be part of a public knowledge. And the process can be pretty complicated. Once you submit the application, you will hear back from the patent office in what's called an office action. And that basically, and usually it contains one or several of rejections. And the patent office will tell you your invention is not eligible for patent protection because, for example, there's another patent or another publication, or it could be posters or public presentations, or even a university thesis that's sitting in a library where it is already in the public domain, so your invention is not patentable. And what you do in response is you could explain why your invention is different from all of that public knowledge. You could also describe why it wouldn't be obvious, because that also is a category of invention that wouldn't be eligible, right? If someone can say this is obvious in view of all of this public information, someone in the field can fairly easily figure this out, then that would not be eligible for patent protection. So it is your job at that point to explain back, okay, mine is different from public information and it's also not obvious for X, Y, and Z reasons. And another approach you could take, and it's not mutually exclusive, you could do both, is you could amend your claims. As I mentioned, claims are really what defines the scope of your invention. So if there is something out there where there may be overlap, you can rewrite or amend the language so that you're not you're sidestepping that overlapping region. This process can take a while. The first office action back, so the response back after you submit your application, could be well over a year just to get that initial response. And the total pendency of the patenting process, the average is about 2 years, but especially in tech fields where there's just more searches to be done and it's a lot more complicated because there's more patents in certain fields, it can be upwards of 3 to 5 years, which of course is a very long time when it comes to innovation and fast-moving industries. And there's a large backlog at the patent office. This, by the way, is the USPTO dashboard, which is updated regularly, and it gives you a sense of how much activity is going on there. And at the end of the day, after you go through that process, right, what does that give you? Where does that land you? It's not, contrary to popular belief, it's not the right to use the invention because you already have that right. You didn't need permission to do it as long as someone wasn't, able to exclude you from it, right? But what the patent gives you is you can continue to use the invention and you can exclude others from making it or using it or selling it. And that is important because that gives you then the power to, for example, you can, of course, it's used in litigation to assert that right if you believe someone is infringing your patent, but you can also use it, for example, in licensing negotiations, and that could include receiving royalty payments in exchange, but it also could lead to cross-licensing, which happens fairly frequently in industries where there's a lot of patenting activity. So that would be if I'm telling you, you can use my patents, and in exchange, I can use yours. And that is pretty common as well, and increasingly so. But that's not the only way of asserting patent rights, and I think this is why it's also important to make sure that all groups are included in the consideration of inventorship. And that's an example of that is patent pools or patent pledges. And what that means is you commit to share your patents with the public. So you dedicate it to the public, and as you know by now, your invention is already described in the public at this point, right? Because as part of the patenting process, you have described as in your claims what your invention actually is and what the scope is. So instead of doing all the activities I just mentioned, licensing, litigation enforcement, you can choose to share it with the public. And one example is Tesla, I believe a few years ago, did this and received a lot of attention. And more recently, there's the Cobit patent pledge, which is that several companies, some of which are listed here, they have come together and pledged that their patents or some of their patents will be provided to the public without any royalty payments. And it is limited in scope. It's only for COVID-related advances, and it's also for a limited duration. I believe it's a year after the World Health Organization declares that it's no longer a pandemic, or January 2023. So there are restrictions on it, but generally it gives you the right to use their technology or license it without providing payments in return. So again, giving or obtaining patent rights, as with other IP rights, gives you this form of property right, like owning a thing or owning real estate. Those are all property rights too, but intellectual property, I think for us, it's really important to recognize what you have in your possession that may qualify and how you want to protect it, because it gives you all of these powers to either assert it or, in some situations, not assert it. You could choose to dedicate it to the public. But the point is, and the important part is, that it gets to be your decision. I'm going to switch gears a little bit and switch to the trade secrets part of this. And trade secrets have a pretty specific definition in the legal field, although it can vary a bit from state to state. And it's generally understood to be something that's not known in the public or readily ascertainable. And readily ascertainable means someone in the field who has experience can look at the publicly available information and understand or determine pretty quickly what the trade secret is. Trade secrets also have to derive some value from being kept confidential and secret, meaning that, you can't just be some scribbled notes that you have that you keep somewhere extremely carefully hidden, but if it means nothing to you and if it means nothing to other people, then it's not valuable, right? And that wouldn't qualify as a trade secret. And in order to be able to assert something as a trade secret, you need to have measures in place that you can show are reasonable efforts to maintain its confidentiality or its secrecy. And there's some, famous examples like WD-40 or Coke, but there's quite a range of different types of trade secrets available. And here, this is meant to provide you a general sense of what types of information can be considered trade secrets. And that can be sales such as specific terms in your contract, or information about vendors who you would want to work with and who you wouldn't, and for what reason. And similarly in finance, it could be analysis of the market, which is very frequently litigated because, as you might imagine, that's very important and helpful information. There are also HR and marketing related information. And again, this is a very short sort of overarching information about what kinds of information can be identified as trade secrets. And these are all the types of information that have been litigated, where parties have asserted them as trade secrets and there has been litigation over them. And as you can see, there's quite a range, and even things that you might not think of as trade secrets, it's not a Coke formula or some way of manufacturing something, there can be quite a big range there. And I would like to encourage you, those of us who, especially in tech, but other areas as well, look to many of the different departments within your business to think about what are trade secrets and what do I need to have reasonable measures in place to properly protect them. And engineering, I want to touch on since that's obviously a big factor in the tech-related fields. So source code, lab notebooks, and ingredients and compositions are pretty frequently asserted as well. For lab notebooks, it's both the lab notebooks themselves and also the information contained from the notebooks that you can then use to make something, right? So if it's like a protocol, then the protocol itself, but also the process that you can implement using those protocols are also trade secrets. And source code is listed here, and that's also interesting to note in that that's an example of a property right or IP right that could be, that's an example of a information that could be eligible for different types of IP right protection. So for example, some of it could be patented, it could be held as a trade secret, or it could be subject to copyright protection. So one of many examples where there could be more than one option. What's also interesting and sometimes not well understood is the fact that there are negative trade secrets also. So what does that mean? It means that we understand generally that WD-40, the final product, is a trade secret, right? But what's also interesting is all of the processes leading up to it and all the rejections, so to speak, along the way, those qualify as trade secrets as well. So this is a trial and error process, the R&D process, all the investments that one decided to not pursue after this investigation period. Those are all part of your trade secrets as well. And that makes sense, right? Because if someone has that knowledge, it gives you the ability to bypass all of it. If you were to change jobs, for example, or set up your own company, you can then kind of move past all of that and you can save resources and money and time and invest them elsewhere. So for that reason, the efforts that go into developing a trade secret, or in other words, negative trade secrets, can also be considered trade secrets as well. And this is another way of looking at the different cases or litigation that has occurred involving trade secrets. And the percentages don't add up to 100 because it's very common for parties to assert more than one type or more than one category of trade secrets. And as you've seen before, there's quite a range in terms of what kind of information can be considered trade secrets, and that they range from customer or business information to technical information and software. And I'll note that the first two, the customer and business, has usually been the largest category of this, but the technical information and especially software has seen a huge growth in recent years, and that's informative for those of us in tech. I want to touch on what it means to misappropriate a trade secret. What does it mean that someone has, you can sue somebody for misappropriating your trade secret? The key word here is improper. If somebody has acquired it or used it or disclosed it in an improper way, then that corresponds to misappropriation. Another helpful way of looking at this is to look at what is considered to be not misappropriation, right? And that includes independent development. If you came up with it on your own, then that's not considered to be misappropriation. If you're able to determine it and figure it out from publicly available information, that also is not misappropriation. And what's also interesting is this reverse engineering concept, which makes it different from patent infringement. What that means is if you were to take a final product that somebody has and you take it apart and you figure out by reverse engineering what that is, then that is not considered to be misappropriating someone else's trade secret, because by being able to take it apart and figure it out, it means that that information in some form is available in the public. And now this is different in the patent context because, as I've mentioned before, for patents, that's already all described in the patent application itself, right? For one, if someone were to take your invention, take it apart, and be able to reverse engineer it, that is still patent infringement. And that's because infringement means you're using what's being described as someone else's invention, and you're using it in the sense that if you look at the product that you're making or selling or what have you, it maps onto the claims exactly. So you have to show that it's element by element. It's exactly what's being described in that patent. And then if that's true, then you are infringing, and that's regardless of whether that came from a reverse engineering approach. And this discussion of patents and trade secrets has certainly evolved over the years, and that's for several reasons. One is that in patent law, there are a lot of developments about what is not patent eligible, and that has certainly changed. It's one of many examples. There were some recent litigation regarding software code, and there are cases that have held that abstract ideas are not eligible for patent protection, right? And while there's litigation ongoing as to what that really means, realistically what that has meant and the result has been that software is increasingly hard to patent. And I think software was already sort of moving on, so to speak, from patent protection anyway, because software field changes very quickly, and patenting process, as we've seen, is just, it takes a while, right? So people are more likely in the recent years to either protect it as a trade secret internally or pursue other means such as copyright. And then on the trade secret front, it used to be that trade secrets were governed under state law, and every state had slightly different understanding of what a trade secret is, how it's protected, what's considered reasonable measures. Although generally most states, not all states, but most states have adopted the Uniform Trade Secret Act. So there's some general familiarities, some of which I've summarized before, but at a general level, it still varied state to state, and that meant that parties who were considering approaches in in asserting trade secrets had options and had different consideration as to whether they should bring it in state A or state B or state C. And that is now slightly different as well. And that's because whereas before there was no federal law governing trade secrets, now there is a federal law that does, which is the Defend Trade Secrets Act, which is from a couple years ago. And now this gives trade secret owners to the ability to bring a lawsuit in the federal courts. And that has always been true in the patent context, because patent law is considered to be within the purview of the federal government. In trade secrets, it was not the case before, but now if you were to assert your trade secret rights, you do have the option of either seeking state court relief, or you could bring it in federal law under a centralized federal law. Looking at some of the people who typically are the misappropriators of trade secrets, both in federal court and state court, so this is more the recent data, right? It has always been the case that it's usually a employee or former employee or a collaborator or business partner who has been involved in the misappropriation of the trade secret. And that sometimes is surprising to people, but in a way it makes sense, right? I mean, by its nature, trade secrets are going to be controlled pretty carefully. Access is going to be controlled carefully if you have these implementations in place to protect the secrecy of it. So it makes sense that people who have access to it and could potentially know where to get it from, right, would be someone who were either employed by the business or someone who has collaborated with them and had access to that information in the first place. So contrary to, media portrayals or movies, it's usually not someone who's sort of sneaking in late at night. It's like a spy or some unknown figure that does it. It's usually someone that's trusted and someone who has been granted access to that information in some way. So all of this to say why it's especially important to guard the information. I mean, both because trade secrets are required to be, protected with reasonable measures, but also because realistically, looking at recent case law, there's an overwhelming majority of misappropriators that are figures who are people who are trusted and have access. So looking at the patents and the trade secrets side by side, right, there are certainly important differences to consider if you're looking at your intellectual property right and trying to decide which measure to pursue. And patents, as we've discussed before, you are getting your patent right in exchange for this public disclosure of your information, right? You've already described in a lot of detail what your what your invention is in the claims, and in exchange for that public disclosure in the form of a patent, you're then granted the right to exclude others from practicing it. On the other hand, for trade secrets, you really want to maintain the secrecy because that's where it derives its value from. Trade secrets are valuable to you because it's secret, and others could benefit from it if they were able to have access to it. And patents also, I don't think I've mentioned this before, they are limited in their lifetime. So it's 20 years from filing, and there are some exceptions to that, and there can be adjustments to be made, especially if there is a delay at the patent office. But for the most part, it's about 20 years. And after that time period passes, it's considered to be part of the public domain and anyone is free to use it. For trade secrets, it's more interesting and a bit more nuanced in that it does not have an end date, so to say. And I guess in theory, you could have indefinite protection so long as no one else figures it out, no one else develops it independently, or no one else publishes it separately. So you could have it protected, presumably indefinitely, given the measures in place. Patents can be fairly costly to obtain, both in terms of all the registration costs and filing fees and et cetera. So there may be more of an upfront cost. Trade secrets are different in that you don't need to register it with an external body. So it's not this very carefully choreographed process that patents have. All you need to do is decide for yourself, I'm going to keep this as a trade secret because there's no registration cost involved. But what sometimes gets overlooked is the cost to keep something as a trade secret and keep it protected. That can be fairly expensive. So these would, for example, include keeping the facility secure, but given that more and more information is online, making sure that whatever you save on the cloud is protected, making sure that there's limitations to access, especially for employees, and not only employees, but former employees as well. And for patents, your invention is very specifically defined. It's whatever is in your claims, and it's limited to that. And while there's, of course, always constant litigation about how to interpret those claims and what do they really mean, but generally it's you're limited to whatever it is that you described in your claims, and that's it. Whereas for trade secrets, it can be a little bit different, and that's because in interpreting the language, there's a bit more variability potentially in trade secrets. So as we've discussed before, for patents, if you want to say that somebody else infringed your patent, you need to be able to do an exact one-to-one mapping of your claim language, element by element. Every single one of them has to map onto this product that you're accusing of infringing. Whereas for trade secret, that's still generally true that you need to show that the way you describe your trade secret is mapped onto the product that you're accusing of misappropriation, but there's still some variability in terms of whether this is a derived trade secret, for example, right? Is this information that could be derived from what you are keeping as your trade secret? So there's a bit more variation and room for different interpretation. And another consideration to keep in mind then in the patent versus trade secret consideration is what your industry looks like. So is it what's called a patent thicket, which kind of looks like this top picture? There's a lot of patent claims out there, and pharmaceuticals is an example of this. Typically, there are large portfolios. Some of them may overlap, and it can be difficult for you to figure out what tiny sliver there in between you could claim as your own. Or does your industry look more like the bottom, right? It's more of a desert-ish area where there are patches of areas that are claimed, but there are larger areas where you may be more entitled to patent protection. And of course, as I mentioned before, the reverse engineering, that is not a defense for patents, right? So how easy is it to reverse engineer your product? That is also certainly an important consideration, because if somebody out there reverse engineers your invention, then it doesn't matter if you assert it as a trade secret, because the act of reverse engineering and the ability to figure it out in that way is a defense to trade secret misappropriation. So wanted to talk a bit about why IP is increasingly important and also at the same time increasingly complex. And that's because the way we work now and a lot of the inventions that we keep in mind are, and especially in the tech field, are such that it's usually not involving a problem that one person or one company or one patent is going to solve. It's very rare that you're going to come out and say, all right, I solved it, I addressed it. It's going to involve a lot of different fields, a lot of different knowledge base, a lot of different experts, and usually many different companies, even those who were traditionally in competition. And I'm using COVID-19 as an example because that's on what's on everyone's mind, certainly on my mind. And it's kind of an extreme example in that there's really a time crunch and a pressing need, but it is representative of a lot of the problems that we're facing, and certainly in the pharmaceutical and biotech industries, where you have a problem to solve, and in order to solve it, you really need to know how it works. Otherwise, in other words, the underlying mechanism, biochemistry, physiology, how it spreads from a person to person, right, after it manifests itself in a patient. And that would involve being able to detect it and diagnose it, but go beyond it, and tracking that could involve parties such as telecommunications companies or even the government. And all of that is before you even get to the question of how do we treat this and how do we prevent it. So what seems like one problem often is many different problems all sort of mushed together. And as you can see from this list, it brings in expertise from a really wide range of different fields. And what's even worse, or I guess it makes it interesting but also incredibly complex, is the puzzle pieces coming together, like on this picture here, and people contributing it and trying to make sure that it works. It doesn't really look like that. Unfortunately, it really looks more like this. It's a bunch of different pieces. You're not sure how they fit together. You're not even sure if you have the right pieces. And in a lot of times, I mean, certainly in COVID, but in a lot of the more complicated tech-related issues, we don't even know what the final picture is supposed to look like. And add the complexity of the fact that a lot of times it's not just you and it's not just your co-workers, it's other entities. It could be the government, could be your competitors oftentimes, which is more and more frequent these days. And another layer of complexity added to this is there's just a lot more access to information. I mean, to begin with, there's a lot more information to start with, but there's also increased employee mobility, meaning that in the past, typically, employees tended to stay within one company and not really veer outside of it as much. And that's not the case. Increasingly, employees are inclined to move from one company to another. And similarly, because of the complexities of the problems we're addressing, a lot of the information is being exchanged with other partners and collaborators and sometimes competitors. So it's much harder to control the flow of information and much more difficult to ensure that your invention and your intellectual property gets protected in the way that it should be. And I wanted to conclude by looking at the two IP rights that we've focused on today. And as I mentioned, I'm happy to talk about others, though I've focused today's discussion mainly on these two. Traditionally, patents and trade secrets have been viewed as either or. Which way do we want to go? But that has certainly evolved recently, and it's not really considered mutually exclusive anymore. And in fact, more and more companies and more individuals are thinking about it in a more multifaceted way. Which part of this should I protect as a trade secret, and in which part should I protect as a patent? And that's primarily because of all of the reasons that we've talked about, including the evolving legal landscape and also what is considered patentable versus not, and the increasingly complex nature of the problems that we're trying to solve is certainly a part of that as well. So coming back to what we talked about in terms of some groups that are marginalized in IP protection, what I hope to do today was give you an overview of what types of IP rights there are, and especially for those of us in tech, because I think it's a fascinating area that has seen a lot of changes recently. And I think it's a way of empowerment for us to understand what it is that I have that I can claim intellectual property rights on. And I would like to, before I wrap up, encourage you to really think about not only what do I have that's eligible for protection and all these IP rights that are important, but also what do other people have, right? Not just myself, but my coworkers and colleagues and others that I work with. What do they bring to the table? How do they help in this invention? Should they be named an inventor or be part of this trade secret protection process? And I think that's where we really derive our values from, and that's how we would be able to solve these increasingly intricate problems that we face today. So with that, I wanted to thank you for your attention, and I would be happy to address any questions that you may have.
Great. That was really terrific, Hannah. You already have a whole bunch of questions from the audience here. The first one is, love to know the information you're sharing about patents. In health and beauty, it's more common to have to protect trademarks here in the U.S. and globally. This person has a line of products with trademarks, but we're now seeing numerous brands using our marks or a very close version of the marks. So what are the best ways to stop them?
Yeah, and that's certainly true that especially in health and beauty, there's been, and I think fashion is another one where there's a lot of trademark infringement. If you haven't already, it's helpful to register it as such. And there are debates as to whether you should or should not, but in the most part, if you choose to bring litigation later, it is better to have it registered and being able to assert to the other party that this is a registered mark. There's also, for trademarks, there's usually a duration to keep in mind. It's 10 years, I believe, with renewals that can be 10 years. So thinking about the time frame of what you want to do now versus looking ahead those many years down the road, that's certainly another consideration. What we usually recommend, maybe not usually, but a lot of times, especially in fields where like health and beauty, there are many different companies dealing with or trying to address a similar problem, is starting out with a very strongly worded letter, for example, right? Making sure that they're aware, that they know that you know, basically. Let them know that this is your mark and that it's your property, right? And if you wanted to try to work out a licensing agreement with them, that would certainly be where to start. But it's also important to let them know that you consider this to be yours and that you intend to protect it.
Great. The next question is actually one that I've heard from many entrepreneurs. It's, I'm interested in pursuing a patent, but I'm concerned that it could hurt me more than it could help me since it just shows others how my technology works. How do you decide whether or not to go for a patent?
Yeah, we get that question a lot as well. And what also makes it difficult is just the idea of having it out there, right? For something that as an entrepreneur, you've really held closely to your own chest. And I mean, I think we've talked about some of the measures that go into making that decision. Some of it may include, well, how many patents are out there in this field already? And can I actually, is it realistic and is it feasible for me to get a patent in the first place? Because once you start digging in, as I mentioned, even things like university thesis that's been sitting on a shelf for 20, 30 years can be construed as publicly available information. So it can be much more challenging in certain fields compared to others to actually get a patent. So that would be like getting a, whether it's a counsel or sometimes it's other vendors who do this, which is just getting an idea of the patent landscape, how crowded it is and how many overlapping areas there are, such that you'd have to, as we've mentioned before, look for that tiny sliver that you can claim as your own. And in that sense, it also gives you, another benefit of this is it gives you the knowledge of, okay, am I even at the risk of infringing other companies or other people's patents too? So getting a sense of the patent landscape would be a good place to start. And also, in terms of the fear of describing it to the public and making all of this known outside, The way that patents are written, I mean, you're right that somebody looking at it could figure it out, but it's also possible, and people have done this, especially with certain types of technology, where it could be written in a way where it discloses just enough to describe your invention, but not literally all of it, such that somebody can then go and make exactly what you make. And that's because usually your invention is described in some way in a patent, but oftentimes, for example, it'll have to be multiple patents, or it has to be the patent plus some other information. And this may also be an area where you do decide to patent some part of it, but keep some of the more concerning or important parts internally as a trade secret. And that is an increasingly common approach as well, where you take your invention, some of it you give patent protection, and the others you give trade secret protection. And this is also true in that, if you remember earlier in the talk, there's an 18-month period, right, before your thing actually gets published. So you can use that time to, one, keep your invention as a trade secret, because until it's published during that 18-month period, it's still a trade secret internally because it's not out in the public yet, right? You could use the time to negotiate with companies and people that you think are infringing or may be infringing, and initiate those discussions early. I mean, you may have limited power at that point because you don't have an issued patent yet, but you do have a filed application that, will include at least some of the information publicly, but not all of it. So it could give you a leverage at that point.
Great. Our next question is, I've seen in the past in the news that any claims against a company regarding intellectual property had to be resolved prior to selling the company, and that the SEC oversaw this resolution. Is this still true?
That is true in some sense, but not necessarily. So, for example, there are companies where, well, let me back up. So it's true in the sense that this actually does lead a lot of companies to resolve or settle things before a company is then sold to another company, right? So this is something to keep in mind if you are in the process of negotiating, either to sell your own business or to purchase another. But at the same time, it's also true that companies that are currently involved in litigation also, nonetheless get sold or acquired or come to some other agreement, even in the midst of the litigation. So in that case, the SEC can get involved, but a lot of times it really also weighs heavily on the companies themselves to try to figure out, okay, which of these potential liabilities will a company assume, the company that's purchasing, because it's one thing to acquire a large body of patent portfolio or internally kept trade secret, right? But if there's litigation hanging over it, then that can be a pretty big risk for the company that's doing the acquisition. So that is certainly a part of the whole discussion when there are acquisitions and other measures in discussion.
Great. Our next question is, how do you officially notify someone who knowingly established a company and platform with the exact same name that the name and log have now been legally trademarked?
I think you can just write them a letter on either business letterhead, or sometimes it also can be more forceful coming from an attorney, letting them know that, basically what you've outlined in your question, which is, I believe, a prudent decision to mention that the name and the log have now been trademarked, and you now are, at the risk of potentially infringing this. And as I mentioned earlier, sometimes depending on the field and your relationship with that other party, to then offer a license or sort of work toward a way to come to an agreement, because, and I say this as a litigator, litigation is very long drawn and it can also be very expensive. And depending on the field and depending on the technology, you may need to work with these other companies later too, right? So it may be in certain situations worthwhile to try to move toward a settlement or coming to a stipulation rather than going out full on, I'm going to sue you right away. Although that certainly is also can be a reasonable approach too, if this is a repeat offender, or, you've taken the more conciliatory approach and it hasn't worked. And also increasingly, because there are a lot of, and I think this goes back to the beauty and health industry question earlier, when there's a lot of infringing activity, sometimes it can be helpful to just send a strong message publicly. And certainly for a lot of companies that have seen themselves at the end of things where they're being infringed, it can send a pretty strong message to sue a company or taking a aggressive stance. But we certainly don't recommend it for every situation, and in certain situations, it might just make more sense to come to a licensing agreement. And that's especially the case if you may be interested in their intellectual property as well.
Okay. Our next question is, how do you protect visual art, especially as it's shared on social media?
Yeah, so with social media, it definitely gets more into tricky category. Depending on the platform, and this unfortunately really involves being informed and knowing about who owns what. There are platforms where it's considered to be part of the platform that on which it's being shared, right? And there are other platforms where they make it more clear that, no, you still own it. But sometimes that line can be kind of blurry. And what we've also seen is that, especially with smaller companies popping up, I mean, everybody, it seems like, wants to get into social media, right? With smaller companies popping up that do that, it's harder to know where it stands. So if this is a concern for you, I would certainly consider carefully where and on which platform you are sharing it. And though people sometimes seem to think that just marking it as such is enough, it may not necessarily be. I mean, there may be an overriding agreement that could be like a user agreement you clicked on when you signed up for your account, for example. Another difficulty of this is that once you share on social media, it could also be shared with other people, right? And you no longer control that process. And some measures that people have done is watermarking it or making sure that you register it in some way so that it can be tracked a little bit more easily. But you're absolutely right that it is a concern and it is becoming increasingly difficult.
All right, I think we have time for one more question here. I am a training consultant, and sometimes I refer to published material and reputable research to build into my training materials. But I always mention the source at the bottom of my presentations. Am I unconsciously infringing?
Oh, yeah, no, that's a great question. That gets me all excited as my IT nerd. So you may have seen in my presentation, too, where I put the source or the website where it came from. One quick tip is when you do Google image searches, right, where a lot of us pull images from, there is a tab, I believe it's either settings or tools, and it might be tools, and you can limit the results that get displayed to only pull the ones where, for example, it's permitted for reuse or permitted for commercial reuse, so that you can be sure to use images where the copyright owner or the content owner has given permission for others to use it. Unless you filter it that way, if you just randomly grab and pull from the internet, then yes, you're potentially infringing other people's trademarks or copyrights, so that is possible. Now, I mean, is someone really going to look at your PowerPoint or whatever, especially if it's only for yourself or a small audience, and comment you and sue you? I mean, probably not. But again, as an IP nerd, that is good practice because it sounds complicated, but it's pretty easy once you do it. Just use the tools that you have available. As I mentioned, Google Images makes it fairly easy. You can limit to certain types of reuse or permitted for reuse, and that still gives you, especially in this day and age, a pretty large body of work that you can use. But also want to commend you, whoever asked this, for thinking about it. I think a bigger theme here is not only recognizing your own IP rights, but also recognizing others and paying tribute to where it's due.
Great. Thank you so much, Hannah, and thank you all of you at home for joining us today. Don't forget to leave us feedback. We want to hear what you think, and hopefully everyone has a great afternoon. Take care.